Evening, everybody. Before I open the meeting, we have a couple of people that are normally not here at the meeting. Definitely one, Councilman Chambers, good to see you again. But we have Mayor Ross who wants to address the board. So, Mayor, the floor is yours, sir.
So good evening, Mr. Chair, board members, city attorney, deputy city clerk. It's good to see you. So a couple of reasons I'm here. I could have delivered this message. In fact, you may have already gotten it from your city attorney or from council member Chambers, but it's a good opportunity for me to come and drop in and visit with you too. I like to do that every so often. I try to get to every board once a year. I don't always make it, but there's a lot of it. So anyway, good to see you. What I wanted to talk to you about tonight, and you may have heard this, you may not, I don't know, but we are working to tweak the ordinance that concerns your terms of service. And have you heard of that? Did anybody? Okay. So I wanted to get here and talk to you myself and just to reassure you and let you know from me what we're doing. When we appointed all of you, we appointed you at the same time. And normally, like we have stood up new boards, and when we do that, we have had the foresight to stagger the terms of the initial members. However, when we appointed you, it wasn't something that we had tons of times to think about. It wasn't an anticipated thing. And so the controlling ordinance for the BOA is an ordinance that has existed for many years. It didn't occur to us that this was going to cause a problem when we appointed all of you at the same time, for the same length of time. And so what we're trying to do is figure out a way to stagger the next terms so that we don't have everybody leaving or terming out at the same time. We sincerely hope that all of you will reapply. And if you're concerned about the date coming up, I think your terms end in August. The way the ordinances on all of our boards are written, your term continues until you are replaced. So we don't really have that time crunch. So when you reapply, what we will be doing is appointing you to different length terms. So I wanted to explain this because I don't want Miss Young to say, oh my gosh, how come Miss Anderson got a 3-year term and I only got a 2-year term? They don't like me. And so that's not the case. And so we're just trying to, and we think we have come up with a way to do this so that nature will take care of itself in the future. We only have to touch this once. So we think probably that the next term will be the only time we'll have to artificially touch this, that it'll take care of itself after that. So one thing that we are going to do, because we sat around and thought of, well, how are we going to pick who gets which term? And we will figure this out. We have secret ways of doing that. If you can't, but what we do want to do initially, before we get to that point, is ask you. And so we're going to, when you reapply, we're going to ask you if you have a preference between this length of a term or this length of a term. And it could be that you guys do it yourself and we don't even need to make the decision, that there's enough people that are willing to, So anyhow, I wanted to come here and explain that to you and set you at ease, because we really appreciate what you are doing for us. And we don't want to do anything that's going to be misunderstood or people are going to get upset, or that's the last thing we want, because we really appreciate what you do. So that's it. That's what I wanted to tell you. If there's any questions, I'd be happy to try to answer them. Okay.
We good?
I have a question.
Yeah.
How long do you think what length of terms are you going to be awarding people when they reapply?
It's up to it's 3 years now, isn't it, Pam? It's 3 years now, and I think we're just trying to change the language.
Oh, 2.
Is it 2? Okay, thank you. So it's 2 years now. The language that we came up with is up to a 3-year term. That way we don't have to change the ordinance again. And so when we go to appoint it, the ordinance empowers us to appoint you up to a 3-year term. And I think what we're going to do is give you okay, would you be interested in a 3-year term, a 2-year term, or a 1-year term, and see what happens? And that way we'll have different, just like city council, we can't have the whole council, it's why we have elections every 2 years, for the same reason. And so, this may give you an opportunity, well, it will give you an opportunity to have up to a 3-year term instead of 2, which is really better for everybody, because it takes a little while to get your legs under you when you're on these boards. So, anything else?
No.
Well, thank you. Thank you for letting me barge in on your meeting and
Thank you, Mayor.
putting
Appreciate
me
you coming
first.
in.
And I want to thank Mr. Benjamin for letting me cut ahead of him on the agenda also. So, you think of any questions after? I'm very easy to find. Just let me know, and I'll be happy to. Or if you have suggestions, it's not done yet. We still have another reading of the ordinance, so we'll be happy to take any input or ideas that you have. So, thank you very much.
Thank you. All right. Moving on with the official part, the July 30th, 2024 Temple Terrace Board of Adjustment meeting is now called to order. Would you please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, next item agenda is the roll call. Board members, would you please state your name for the record?
Byron Longworth.
Stan Cope.
Stephanie Young. Tony Anderson.
All right, and have all the members received the minutes from the May 23rd, 2024 meeting? All right. Are there any corrections or additions to these minutes? Sorry. All right, do I have a motion to approve the minutes?
Motion to approve the minutes.
All right, and a second?
A second.
Second. All in favor, say aye. Aye. Any opposed? Motion passes accepting the meeting minutes for the May 23rd, 2024 board meeting. All right, before we start, I want to briefly explain the Board of Adjustment procedures for tonight's meeting. Please listen, and if anyone wishing to speak on any of the matters discussed tonight has questions, please ask after I finish explaining the procedures. The variance request will be heard, and the board may approve with conditions, or deny the requested variance tonight. Alternatively, the board may continue a case to a specified date upon the request of the owner or applicant. A staff report detailing the variance request and the staff's recommendation will be presented to the board by Community Development Planner Malik Hall. The board may ask questions of staff. The applicant will present their application and answer any questions from the board. Next, the board will hear from other persons wishing to speak on the application. Comments should be limited to relevant factors. The applicant will be allowed to respond to comments from the public. The board will then close the public hearing for discussion on the petition. Upon no further discussion by the board, the chair will ask for a motion. The motion must state the reasons for granting or denying the application. Staff will provide written correspondence to the applicant and owners after this meeting regarding the approval or denial of the application. If approved, the owner may submit the appropriate building permit applications, or the city may proceed with reviewing building permit applications that may have already been filed as a result of the board of approval of the variance. However, please note that any action by this board is not final for 30 days, and if the applicant moves forward prior to the expiration of 30 days, they do so at their own risk. Does anyone have any questions about the variance process at this time? All right. All persons wishing to speak or be heard on the variance petitions, please stand up to take the oath and be sworn.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. City Attorney Shoshone will ask if board members have any ex parte communications.
At this time, if each one of you would state whether you have had any ex parte communication with anyone concerning this particular item, and if it was in writing, please provide a copy of that to the city clerk. Whether it was in writing or verbal, please state now whether or what the sum and substance of it was, with whom you had that communication, and when that communication occurred. And start with,
No, I haven't.
I'll start to my left.
I have not had any ex parte communication.
No, I have not had any.
I have not.
I have not.
Thank you.
All right. The Temple Terrace Board of Adjustment will now open the public hearing on the variance BA 24-03 for 332 Ferncliff Avenue as submitted by Kelly Benjamin, property owner and applicant. The staff presentation will be done by Community Development Planner Malik Hall. Please make the staff's presentation regarding variance request BA 2403.
Okay. Good evening, Board of Adjustment, members of the public, and members of staff. We are here today for the variance BA-24-03 request, which is subject property 332 Ferncliff Avenue. Background. So for this property, it is located in R10 single-family zoning district in the X flood zone. The approximate acreage for the property is 0.23 acres. The existing variance for this property is BA-22-10, which is to allow a pool in the side yard. The property currently has a gross area, the home on the property currently has a gross floor area of 3,008 square feet. This is 2 stories, has a carport, a driveway, and of course a pool that was related to the already existing variance. The variance requested here tonight is to have a pool enclosure in the side yard, so an enclosure for the existing pool. This is necessary because they are technically 2 separate accessory structures within our code. So because the original variance did not include language or allowance for the pool enclosure, and they are 2 separate accessory structures, we must have to go back to the Board of Adjustment, and the applicant must request for the enclosure. This is an overhead image of the property and a side-by-side with the site plan. The setbacks submitted show 8 feet to the decking around the actual pool, and then 10 feet to the body of water, I guess the pool outlining itself for the side yard. And then for the rear, it's 10 feet to that outer portion and 12 feet to the body of water. Are there any questions? Oh, to add, the application had 2 out of the 9 hardship criteria as positive. So 2 out of the 9 were in favor of the applicant.
All right, thank you. Are there any questions from any of the board members regarding this request?
So are you saying, are you suggesting we approve or suggesting we deny? Based on your findings?
Based off of the findings, they aren't in favor of the applicant. Only 2 out of the 9 were met, so I can't really give a recommendation per se. I just know the findings aren't in favor.
They are in favor?
They are not.
They are not. Okay, thank you.
No problem.
One question. I don't know if the applicant's going to speak on this, but is he taking up any more land space, or it's just the enclosure on the current space?
It should be just the enclosure on the current space based off the application.
Okay.
Just the enclosure for the pool.
Okay.
There won't be any additional lot coverage taken up by the proposal for this variance.
So what is the variance actually for then? I guess I'm trying to...
The enclosure, because so the pool is an accessory structure,
Correct.
but then the actual enclosure is also an accessory structure. And for the original variance, it addressed the pool, but not the enclosure.
The enclosure has nothing to do with the land per se?
No.
Okay.
No, the enclosure does not have any lot coverage or any building coverage because it's not impervious to to weather for a roof. So a roof structure, for it to count towards that, would have to be impervious. The enclosure itself, amount of land added is not applicable for this application.
Okay.
I just have a quick question. I know that you weren't here last year. This is one that we all probably remember pretty well. If he had asked for the screen enclosure at the time he asked for the pool, would you have advocated that he should have the pool but not the screen enclosure? Or would you have said it just because he asked for both, he gets both?
So I will say that based off of our documentation, our records, the planner at the time actually was not in favor of approval. But the board did approve despite his recommendation.
Yeah, he won. He won pretty good with that one, against the very vigorous argument from the city against it. He won, but I'm just asking if basically, if there's any basically, if hypothetically we rehatch the same arguments over again, but he would have asked for the screen enclosure at exactly that time, would it have mattered?
If there was not an existing safety barrier, so technically the subject property meets the safety barrier required for pool enclosures due to the fencing around the property and the wall. I guess technically if the property did not have a fence or safety barrier in place, it would give justification to have the enclosure because then it would be a safety concern. So if that was the case then I would say there's grounds for recommendation then, but there is an existing safety barrier, so.
Okay.
Any additional questions from the board?
I'm sorry, I have one more question. So what code are we actually
For the safety barrier or for the
for the enclosure? Because
12-508?
okay, which is what? I'm sorry.
It's for accessory structures and I think that reads site features.
Okay.
Give me a second. So the code actually is that they're required to be in the rear yard. So in the background I have my staff report. In Ordinance 1050 enacted September 2001 contains the language that requires pool enclosures to be in the rear yard.
Okay, so this is supposed to be in the rear yard and he wants it on the side because the pool's on the side.
Correct.
Okay, all right, there we go. That's
Sorry,
all.
I guess that should have been something I...
It's okay, thank you.
All right, any other questions? Oh, thank you, appreciate it.
Thank you.
All right, we will move on to the applicant's presentation.
Do I need to unplug the laptop?
Did they get the laptop worked out for you, sir?
No, I just have mine that I can kind of show you what I'm talking about, but,
Hang on just a minute, I'm getting from the, oh, okay.
someone said that they can zoom in on.
Oh, okay, I think that's what I'm getting back there. Sorry, I wasn't reading the hand signals too terribly well, but,
First,
just,
thank you.
let me just one quick, give me a couple things here. I do need you to state your name and address for the record, please.
Sure, my name's Kelly Benjamin, and I live at 332 Ferncliff Avenue.
Thank you, Mr. Benjamin. You may start your presentation. You have 15 minutes, sir.
I want to thank all of you for, coming out here on this rainy night just for this one variance hearing. I also want to thank Malik. He's been incredibly patient with my persistent calls to his office regarding this matter, and I appreciate his professionalism in this process. My variance petition request is as he stated in regards to the pool enclosure. As you probably recall, I came before this board in 2022 with the request for the pool based upon the existing layout of my property and the trees surrounding the property, which made it impossible for me to place the pool in the backyard. There was ample space on the side yard. This board determined that there was a hardship regarding the pool. I later went through the process of building the pool, looking at the order for this variance. There was a request made at the time, if folks recall, to build a wall in front of the facade of the home, to extend an existing wall rather, which I have done. I have a photo here of it, so the board can see. I don't know if, it's not the best situation. Let me see. Okay, there we go. So that's the wall. Has a gate because originally this was like a horseshoe-shaped driveway that went through. Now the garage doors open on both sides, and there is foliage surrounding the pool entirely. On this next slide here, I'm going to try and zoom in here. This purple area denotes the wall that was constructed, and this green area here is the foliage surrounding it, and then we have the blue here is the area that is where the proposed enclosure for the pool would be. It is going to be below the second floor. It's going to come in below the second floor window. Because of the placement of the wall, which I just showed, there's not going to be a whole lot of visibility at all from the street, which I think maybe was the original intention of this ordinance. It's not going to be in any way sort of a hazard for people viewing it when they come down the street, both because of the height of the wall as well as existing foliage. If you see this, I didn't do a very good job of placing this green dot. I don't know what just happened to my screen, but this green dot is, there's a huge live oak tree in the backyard. It's actually closer to this small dot. I don't know how it got messed up on this version of this. Sorry about that. But it's hanging over the pool. And which, you know, if anybody has ever cleaned out a pool in Florida, you have leaves, you have pollen. I love the tree. I don't want to touch the tree. But because of that, it creates, you know, kind of an issue with daily cleaning, particularly in the season that the leaves and pollen are falling. In addition, you know, a lot of folks, my neighbors and their children come in, they swim in this pool, and there's like mosquito issues, as folks know here, at certain times of the day. So we thought, oh, let's move forward with building the pool enclosure. My understanding, based upon the previous hearing, was that the hardship had already been determined, and that, and this was a conversation that I had with Gus Carpus, who I understand is no longer here at the city, that once this was determined, this wouldn't be an issue. So I went ahead and contacted a contractor. I signed a contract. I gave him a deposit. I applied for the permit through the city, and it was denied. And there was a long process towards getting here, but I didn't think there would be any problem based upon my understanding. Looking back at the ordinance, it did, it required the wall, which was constructed, but I did not recognize that the determination of hardship would not cover the pool enclosure as well. So I'm here today to request that. I also have a petition. I went around to all of the surrounding neighbors to inquire if they had any problem with a pool enclosure being built. I can pass this around because I apologize I didn't make copies. And all of the surrounding neighbors on my street, as well as the street behind me, have signed the petition stating that there is no issue with this pool enclosure being built. And particularly for the folks with children, they're excited because their children won't come home with mosquito bites. So, I also just wanted to mention, if you drive around my neighborhood and the surrounding community, you will note that, there are existing side yard pools, there's side yard pool enclosures, and in my neck of the woods near the golf course, there's not a grid. It's sort of, there's a lot of like wavy, windy streets, and some backyards face the street. Because of that, some backyards face the golf course. And so you see a lot of, screen enclosures. It does not, damage the integrity of the neighborhood when you see that. That is going to be minimized by my, existing wall and the way that this pool enclosure is planned out. Again, it's not going to be up to the roof eave. It's going to be below the second floor window, and very minimal visibility from the street. And that was the intention, because I did not want to spark any issues whatsoever. I'm trying my best to do the proper channels, and I would really appreciate an approval of this variance, and I'm happy to answer any questions you may have.
All right, is there any questions from the board for the applicant?
I have a question. So, had you been able to go back in time 2 years ago, was your intention at the time when you sought that variance to be able to get the enclosure as well? Like, is that what you thought you could do whenever you got that one variance?
I did believe that it was possible to get the enclosure as well, based upon my understanding of the determination of hardship and my conversations with, I believe it was Gus Carpus, and, you know, I think potentially why Eric Kravitz is not here, because he came by, he's campaigning right now, and he came by and knocked on my door, and we talked about this issue, so I think he recused himself from this meeting. But my understanding was, yes, that this was something, it was a hardship that was already determined based upon the layout of the pool. And I also recall that, you know, this board made a request to the city council that they review the issues pertaining to this structure. And I don't know where that process is. My understanding, I think Mr. Hall mentioned that what is being reviewed might not even pertain to this issue with the side yard pools. I thought it was in the works. This was 2 years ago. I'm not sure where that process.
I just have one more question though.
Yes, sir.
So, I mean, you mostly answered it, but I just want to say, if you knew 2 years ago that you were not going to be able to build the screen enclosure, would you have asked for it that day?
I would have asked, but here's my other, you know, contingency. At that time, when I inquired with the pool company, Riviera Pools, about building an enclosure, the price for the enclosure was quite high. The price has gone down. The price of aluminum's gone down. Various things have gone down. So I did not, you know, put that in based upon, at that point, I could not afford it. I can now. And so that was part of the issue. And I also would, you know, maybe that should have been part of it. If I knew this was going to be, I would be back up here again 2 years later going through this process, I would certainly have asked for it then, because my understanding, based upon the determination of this board, that it would have been approved. And that's why I paid the deposit. I'll lose that deposit if this doesn't happen. But I'm hoping that, you know, this will be approved. But again, like I wasn't entirely, I would have loved to get them both approved at the same time. That would have been ideal for.
Yeah, I'm just trying to basically gauge if this is just like an oversight, basically, kind of like that's like basically like more like you just would have asked if you could have. Like,
The
or if you're
original plan
aware.
was always to have a pool enclosure.
Yeah.
I wasn't if I knew that it made a difference if we had it, you know, approved then versus now. I would have done it 2 years ago. I would have saved everybody a lot of heartache, including Mr. Hall, including this board. You know, I would have loved to have had it all taken care of back then.
All right, thank you.
You don't have any questions? I do have one, because this is, and I think this is probably a follow-up to you, but I think you were also, and maybe it never was perfectly clarified, but you were also going into the assumption that this approved not only the pool, but it approved the lanai as well, correct?
That was my assumption, yes.
Okay. Right, wrong, or indifferent, that's what you truly came in here believing when you came in the last time, because I think I'm the same way, or it would have been in the application.
Yeah, well, yes, because you know, obviously I'm not going to put a pool enclosure anywhere where there's no pool. And the idea was that, you know, that this hardship determination was based on the layout of the property. Layout of the property is exactly the same. This board determined that there was a hardship based upon that at that time. So my understanding too, because I followed up. You know, I'm probably a bit of a bug in some of the city staff's ear regarding these issues, and you know, because I had mentioned this issue to the city council later on after this. You know, we were hoping to move that ball forward. I would have loved to get that all taken care of at that time, and that was my assumption. Upon looking at the order, which Michael Sherman emailed me when this whole process started, I realized, oh, yeah, I had to put an enclosure into the original plan, and so that was an oversight.
All right, thank you.
Thank you. Any other questions from the board?
I have a question of the applicant. For the sake of the record, Mr. Benjamin, what is the hardship for the pool screen enclosure? Something that runs with the land and not because of mosquitoes that everybody deals with.
Right. The last time I was here, I had a video that I showed that laid out the setback, because the house is set very far back on the property, and there's two large oak trees on either side of the house. The setback for a pool, I believe, is what, 25 feet, more or less, from a live oak, And that made it an impossibility to put anything in the backyard whatsoever, and it's a very narrow backyard. That was the hardship, was the placement, of the house on the property, and the placement of all of these protected trees on the property.
So are you making use of your property without a pool screen enclosure?
Not to its fullest and highest extent, the idea is that,
Well,
when we,
reasonable, are you making reasonable use of your property without a pool screen enclosure?
well, we live there, but we bought the house in the hopes of, because we bought it from the original owners, and they had always intended to, they constructed the house. If it was built, the house was built in the 60s, if they had built a pool there within the first 3 decades of the house's existence, this would have been no problem. But here we are, and I believe that this ordinance was passed sometime in the 90s, I'm not sure exactly when, but that ordinance changed, and that's why you see so many existing side yard pools. But, to enjoy the fullest, and highest use of the property, we would love to have a pool there. We have a young child, a lot of kids in the neighborhood in the pool.
But you understand that those things, the people who live in the property have nothing to do with whether there's a hardship. So your children or not children, that has nothing to do with a hardship. It has to be something that runs with the land.
Right, and I think the board determined last time around that it was the layout of the property. It made it impossible.
So you asked for a pool then, but you didn't ask for a variance for the enclosure at the time, correct?
That is correct.
And because you couldn't afford it at the time, you weren't interested in having it then?
No, that's not correct. That was always the original plan, is to put a pool enclosure.
So you neglected to
together.
apply for the variance for the pool screen enclosure at the time?
My understanding was that the determination of a hardship included a pool and an enclosure.
Did you see your application at the time that was submitted for approval?
Yes.
And there was no mention of the request for the variance for the enclosure?
Again, I talked to the city staffer, Gus Carpus, around this issue. His understanding that it was conveyed to me.
It wasn't written on the application, correct?
I understand, ma'am.
Okay. So you had got a non-conforming you got an approval for a non-conforming pool, and now you want to exacerbate the non-conforming use there by putting a pool screen enclosure over it.
Those are not the words that I would choose to use. I'm attempting to enjoy the fullest and highest use of the property based upon the layout of the property and what we would like to do. We moved into this community, I knew there was, a set of rules, and we're attempting to work within those guidelines. And our understanding was that, once this variance was approved, that's why we went through, I didn't think that this permit would have an issue going through at all, which is why I went ahead and, gave someone a pretty hefty deposit, a contractor, on this issue, because I thought it was already something that was determined as a result of this. And that's why we're here today, 2 years after the fact. It was something that I wish that we had discussed 2 years ago, but it was not my understanding that was necessary, and that's why I'm back in front of you today.
All right, I have another question.
Yes, sir.
You said very little about why your petition says you're here, which is oak trees dumping debris into the pool. How often are you cleaning it?
I'm cleaning that pool on a daily basis.
Okay,
It's a daily situation.
okay. All right. So how long does it take you to clean the pool whenever you do it? Just curious.
It depends on the time of year. In the wintertime when the leaves and pollen are dropping, it can be a half-hour-long process. And folks that have a pool might recognize that, the pool companies have a tiered system. If you don't have an enclosure, there's a higher cost to pay for pool cleanings. At the moment, I'm cleaning the pool myself, and it's there's less right now dropping. Occasionally during the storms, you get moss and bark and leaves in there, but in the months that the leaves and pollen are dropping, it's a daily occurrence. In fact, I've had to have the pump pumped out twice. It's like $100 each time that happens. So, if that is, that's a hardship for me personally, that's an issue that I'm, having to deal with and would be a consideration if this board decides not to approve it, whether or not I, remain in the home, because I'm kind of like committed now to this thing. I'm constantly doing that. I would like to have an enclosure there to, avoid that situation.
Okay. And do you have any pictures of the debris in the pools?
I do. It might take me a moment to find them, but I do.
Yeah, that's the,
Take your time. We're good.
that's the interesting part about your petition. We were talking about all the other stuff.
What? Tell me why it's interesting.
That's what's,
What?
that would be the only part that would be the hardship to the land.
Oh.
Or perhaps, I just want to see if it's,
It has to be something not experienced and suffered by others. So falling leaves, and you have to think about that.
Can I ask a question really quick, Pam? So the state of Florida, the Water Safety Council is trying to institute a law where every single pool in the state of Florida has to have an enclosure due to water safety. It reduces the chance of accidental deaths by 70%. So if that were to be enacted and that was a requirement in the state of Florida and we were not to approve him today, would he then be approved?
But that's after
Haven't read that. I would assume that it would apply to pools that are built after that law goes into effect, and not suddenly requiring everybody who has a pool to suddenly build us an enclosure. So-
I'd also like this on.
Let's see. You mind if I pass your phone
Oh,
down?
hello?
Yeah.
I don't know if it matters, but the way that, so in our ordinance, the safety barrier I mentioned, we have an ordinance for safety barriers for that reason.
Yes.
So currently, fencing and walls suffice. I don't know, I'm not up to speed on what you're talking about. They may do a change that is for specifically enclosures, but as far as the safety requirement, the fencing and wall meets that requirement.
Here's another one that I have other pictures of it, if anyone wants to see it. It accumulates in like this one particular corner fairly regularly.
okay. All right.
All right. Are there any other questions from the board? All right, Mr. Benjamin, thank you. But you might want to stay there, because my next question is going to be if anybody else wants to talk, and then it's back to you. So I have a funny feeling you don't need to go anywhere. But I will ask, just in case, are there any other persons wishing to be heard regarding variance request BA 2403? If so, please come to the microphone, state your name and address. All right, that's why I said you might want to stay there, because applicant, you have the final word. Do you have anything you wish to present in light of any public comment or board questions? You have 5 minutes for rebuttal.
No, I have other photos, and I apologize for not having more of them available on my phone that show the amount of debris that does accumulate. It's quite a process, cleaning the pool due to this large overhanging oak above the pool. Again, I feel that that's a hardship. I tried throughout this process to go through and do exactly what the city required. I moved the pool, if folks remember, a couple different times based upon what the previous city staffers asked. It was originally at one place. I moved it back 5 feet. I moved it to the left to make sure that it would minimally impact the existing ordinance. The wall was constructed in a timely manner shortly after the pool was constructed, and we love this neighborhood. But when I start thinking about and I don't intend to move, but when I start thinking about cleaning this pool every day for the rest of my life, I'm starting to wonder about what my future looks like here in this community. We love Temple Terrace. My wife is a school teacher across the street at River Hills Elementary School. My daughter goes to school there. We have, again, this is our home. This is our community. We'd really love to have the enclosure, and I thank you for the consideration.
Great, thank you.
Thank you.
Mr. Benjamin, any pictures that you showed to the board, you must provide a copy of those to the city clerk for the record.
Absolutely, I'll do that. Is there a particular email address that I should use? Thank you so much.
All right, if there are no further comments from the Board of from the Board of Variance, BA 2403. I hereby close the public hearing and the board may discuss the application.
Okay, I just want to say that I'm going to be voting yes on this variance. The reason is because I would have absolutely voted yes on the screen enclosure if we would have asked for it 2 years ago. He discussed basically debris dumping into the pool. Everybody else gets to have a screen enclosure in the city except for him. So this is just, in my opinion, the variance, the same reasons that the last variance was granted for having the concrete there to begin with implies for the screen. There's a separate hardship due to the debris dumping in. Now we have a rule that only he can't build a screen porch, everybody else can. I frankly find this, I would have probably just granted the permit, truthfully, if it were up to me, rather than having this whole meeting, but I'll be voting yes. Because of the hardship of the debris falling into the pool, and for the reasons why the pool was built initially.
You all have any comments, or? I mean, you don't have to announce how you're going to vote yet if you don't want to.
No.
That's, I didn't mean it that way. Sorry if it came across like that. but-
Do I have to have this on for discussion?
Yes.
Okay. I'm having a hard time, just based on this solely alone, finding the hardship against the land, which is what we're supposed to do. And yes, I agree. Had 2 years ago, this been included in, it would have been approved. So just because now we have to take this as a separate variance and look at the land and the usage, I don't see the hardship, which kind of stinks, because I don't see any problem with him building a screen enclosure over his pool that we allowed him to build. So I'm kind of torn.
I agree with you, but I also think that he's not using any more land.
No, he's not.
He's not using additional land, he's not adding concrete, he's not cutting down trees. There are proven statistics saying that kids are less likely to have accidental deaths with full pool enclosures versus walls, which I know is our city code, but it should change. So,
It's a state building code.
yeah, no, but it needs to change. So, and they're working on it, so yeah.
I just want to know where the city is changing this ordinance about not having things in the side yard, because we've had multiple people come in and we've denied some, we've approved some, and it's
Yeah.
kind of like,
Wishy-washy.
you know, these, like they said, these houses were built in the 60s, and the way these lots are figured, you know, I don't know whoever did that ordinance in the 90s didn't look at the plats of land and the buildings.
And as a person who previously worked with the staff member that helped Mr. Benjamin, miscommunication was a common occurrence, and so I fully believe that he was told that it was not going to be an issue and he would not need a variance, because, yes.
Despite basically, my understanding at the time we granted the variance is that he probably would be allowed to have a screen enclosure. It didn't even occur to me. And, you know, and I'm supposed to be on the board as vice chairman. I didn't think of that. And at this point, everybody else in the whole city gets to have an enclosure except for him.
Well, that's not true.
Yeah, that's not true.
That's a false statement, because if somebody came in and said, hey, I want to build a
Or an existing pool that's already there.
Yeah, in their side yard, and that's an accessory structure, and they'd have to come before us. Even if the pool was built in the 50s, you know, under the old code, we'd still have to approve it. And there's nothing saying that you have to have a screened enclosure. I mean, I don't prefer having a screened enclosure if I had a pool. I don't have a pool because they're a lot of work, but,
Attest to that.
yeah. I'm just saying, I mean, nobody's entitled to have a screened enclosure in their side yard, because that's the way the ordinance and the zoning is written, and we have to uphold that, so.
Yeah.
Well, that's where I've got a little, and I actually wanted to ask the city attorney, if you don't mind, if the board made a mistake, or if there was a misunderstanding or something like that happens, is there a way to correct that? I mean, is it possible to amend our original order? Is there any options there, or is this where we are?
You can't amend your original order. Right or wrong, you granted him a pool.
Okay.
But you have to look at the request now, 2 years later, for an enclosure as a completely separate application and a completely separate set of circumstances.
Understood. I just wanted to make sure there was not another option. I assumed there was not, but I did want to ask the question, so.
The reason it was approved originally was because of the oaks. This board approved it due to the land. We approved
There's a power line running across.
yeah, and the power line. I actually was not here for your case, so I wasn't in attendance at that meeting. I must have been
but I
absent that
remember
day.
there was-
But, so it was approved for that reason. So if you were to apply right now, and Mr. Hall, you may be able to answer, if you were to apply right now for a screen enclosure for that same spot, that we already said would not work for our pool, we would deny it, we would approve it for the side yard, just like we approved the pool. Because he can't put a lanai on the back due to the land,
No, he could. It'd just be a smaller lanai.
yeah. So,
Well,
There are often cases heard by boards of adjustment that grant pools that are larger than they're supposed to be, or in a place that they're not supposed to be. And oftentimes, a condition on granting that variance is, don't ever come back and ask for a pool screen enclosure, because they don't want, they're granting one thing that is not permitted, and they don't want to exacerbate that.
I was not aware of some of the process with the grant. This is the first time I've gone through a variance process this past, year when we did this in 2022. I did not realize that this would be a separate process, which is exactly why I applied for the permit. I, went through the paperwork with the contractor, signed the contract, gave him the deposit, because I didn't think that this issue would be an issue. Also, I don't know if you can see the screen anymore, but now that there is an existing wall along the front facade of the house, I'm not sure, and if I were to apply for a building permit to add an addition onto my home, along where this purple line is here, it's kind of difficult to see here, but which, by the way, the pool enclosure is 36 feet behind this existing wall, which is now the front facade of the home. There's a courtyard in between, and then there's tall foliage. If I were to apply for that and build a structure there, would that be approved? And if so, would that then create this area? Would that then be considered a backyard?
Exactly. I think we had that same discussion when you were here before, like, if the house were to shifted, when does your side yard become your backyard?
yeah.
Because if I have to go that route, maybe.
Yeah. Yeah,
Build a
we've
whole-
had that discussion before. When does your side yard become your backyard, and where does it start and where does it end? And who's to say what a side yard is and what a backyard is? And, yeah, because it is an odd shaped, the way the house is positioned on the land is unique, per se. A typical, usually people build right to their setbacks, their 10-foot setback on one side and 10-foot setback on the other side, and not have such a large front yard. So, yeah, it is a unique feature of that lot.
And I do believe, I can only surmise the original intent of this ordinance in the 90s, but I imagine it has something to do with visibility of somebody's pool from the street. I've tried to minimize that as much as humanly possible with both the creation of this concrete block wall in the front of the home. And there's also, as Malik mentioned, there is a fence at 36 feet behind the wall that also obstructs view from the street, as well as the foliage that completely surrounds the pool. And then on top of that, there would be an additional barrier with the screen enclosure, if approved.
All right, do we have any other discussion?
Give me the paper I gave you.
James, you were on the board in the 90s.
Yes, thank you. I'm not part of this discussion. I do have something additional to add. Just I guess food for thought. We do have conditions set if it were to be granted. So should I go to the podium to read them, or can I read them here?
I'm okay if you read them there, as long as if he's got you on
Okay,
camera. Everything
just wanted to
like
make sure.
that. So we're good.
All right. So if it were to be granted, the conditions, there are 3 conditions listed as such. The pool enclosure, as generally shown on the site plan, date stamped June 24th, 2024, by the planning division, must not exceed a height of 13 feet. Condition 2, a new boundary survey of the subject property must be provided at the time of permitting. And condition 3, the pool enclosure must be located no further than the perimeter of the pool decking. So there's some conditions to consider. Thank you.
And all those are considered in your drawings?
Yes, I believe that the original plan had the height of the pool screen I believe at like 13.8, something along those lines. Oh, is that what it was? Okay.
Your current building permit application is 12 feet and 6 inches.
Okay, thank you. I thought it was, okay.
Which one? I'm sorry, somebody needs to turn their mic on, I'm not sure. Okay.
Sorry.
Thank you.
On his current building permit application, the peak height is 12 feet and 6 inches, and the lowest height is 8 feet. So it slopes from 8 to 12.6.
Yeah, and it goes straight down, it's not one of these, can't recall the name of the kind of pools that have the peak at the top. It just goes straight down, so it's like minimal visibility. But yes, and it would not, I mean, it's just over the decking of the pool as Mr. Hall stipulated.
So would you agree to the 3 conditions?
I would. Yeah, because that was on the plan, the height was on the plan, the perimeter is on the plan, and I'm sorry, what was the third condition?
A new boundary survey.
A new boundary survey. Okay, so I would need to get a new boundary survey. Okay, if that's what can push this through, I'm happy to do that.
Mr. Benjamin, I will ask this too. Is there anything else that you think you're going to need with the pool in that area so we can address it now?
No, sir, I
mean,
hope that this is it, and I hope never to have to bother you again on these issues.
Slide, planning board.
Yeah, that's, well, I am asking, I mean, I don't know if you have any future plans. I mean, I said that, in a little bit, but I did want to clarify because I don't want to, I'm like you. It's not that I mean, I enjoy seeing you, but I don't think you want to do this a third time any more than we want to do this a third time. So,
Yes, sir, that's correct.
so is there any potential of anything else you think you're going to do in there? Because
No, I mean, there was, like I mentioned, not regarding this pool, no. Like if there was a possibility at some point in the future of putting an addition onto the side of the house, but that's a separate story, and that's
that would
unlikely.
definitely be a separate,
yeah,
without any question.
That's completely
so.
unlikely. In relation to the pool, this is it.
I don't think you could. You're at 46% of your lot coverage.
Okay, but that's what's permeable? Because if it's over the existing driveway, does that matter?
I don't know. You'd have to ask him that. That's not a me question.
Well,
I did notice you were at 46% because that's why I asked him the first question.
I don't even know if we want to open the door.
Yeah.
Wait,
But
let's-
yeah, my plan is not to do anything. This is, we don't have any big plans at this moment regarding the pool.
All right.
This
Anything
is
else
it.
on the board?
Excuse me, I do have a question for Pam. You mentioned a condition that's typically used to prevent, applicants from coming back. Is that something we could put in place here? I don't know if anyone's in favor to it. I just want to put it out there.
Well, actually, that's why I asked that question.
Okay.
This was it, because that's probably exactly that was going to be one I was going to add to
Add
the
on?
list if the
Okay.
board
Understood.
decides to go that direction
No other variances
Nope.
can be.
for the pool,
For
or the
issue.
pool area, correct? And you would be okay with that, I assume, as well?
No other variance for the pool. I can't think of anything else that I would need at this time. Are there any other things that people do to pools? I can't think of
Not that
anything.
your homeowner's insurance will allow you to.
Yeah, I have no, look, I don't want a diving board. Somebody else has apparently a grandfathered in slide around the corner from me. I don't want anything like that. This is it. This is all I would
Not
like.
going to compete with Adventure Island, or, okay.
No, sir, this
Not going
is
to put a
it.
jacuzzi in, or?
I assure you, I really don't want to go through this process again, and I did not expect to go through it today. But I would love to have the pool enclosure.
All right. Board members, anything else? All right, having examined the materials presented, hearing statements from all whom wish to be heard, and the board deliberations, the chair will entertain a motion. Make sure you include your reasons for approval or denial from any board member regarding variance request BA 24-03.
All right. I motion that the variance requested at case number BA 24-03 for the property located at 332 Ferncliff Avenue, Temple Terrace, Florida, be granted as depicted on the site plan represented at public hearing for approval with the conditions cited by the city, the three things that were proposed, and based on upon the petitioner meeting the burden of proof with required by the hardship criteria set forth in 12-72C3 of the City of Temple Terrace Code of Ordinances granting variances as stated, and the evidence provided at this public hearing, specifically that there were reasons why the spot was granted over 2 years ago. The same reasons should apply, as well as the obviousness of the debris that's gathering in the pool, and also his intended use to begin with involved the screen. And for the hardship being the same reasons why the pool itself was granted that location.
Do we need to, I think we probably, for the record, need to state the conditions that you're, I believe it was,
I said it by reference. I think it
was
should be.
no, are we okay? Do we need to specifically say them, or?
Were they attached to the report, Malik?
The three were
The additional condition was.
sorry. The three were attached to yeah, the order granting that I provided to Jen. I do know you wanted to add on a fourth.
Right, and that's what I was gonna ask. Would you have any objection to adding to your
that's
motion that the fourth item, that this
Oh,
would be this would be the final
Final variance. as
variance
a pool.
request for this pool or the pool area?
Yes, and he agreed to that, so that's
No
what
objection.
that's why, so with the four conditions, the three that were in the report and the fourth, that no further variances for the pool be granted if they were brought forward.
Okay. All right, we have a board member motion. The motion requires a second. Is there a second on the motion?
Second.
All right, we have a motion, we have a second, has been made, so, all in favor of the motion as presented signify by saying aye.
Aye.
And all those that are opposed say nay.
Nay.
And so if we have a tie, what happens with this, the city attorney?
Normally, it would fail. There's been some debate in the legal department that it requires a second vote now with a motion to deny. That may end up with a tie, and then basically the application fails, So we need a second motion to deny the variance application.
Which is probably us.
So that one of you two have to do the motion to deny.
I will not be up here again, I promise.
No, I understand that. I'm just,
I'm gonna ask
Yeah.
for this board.
so, all right, so I want to make sure that we've got the vote right. Can we do that again, or are we done? Or is that already?
Your motion was to approve with the conditions. So how many, let's do it by show of hands, how many vote yes?
To the approval with conditions.
Yes. Okay. How many vote no? 2. At this, especially when there's only a 4, it's going to require a vote of 4 in order to approve this. So,
Oh, so, okay, so one vote changing is not going to change anything. It takes all 4 with this, okay. All right, so we don't have enough votes to approve. We don't have a motion to deny.
there's been, again, some debate that the application is still lying on the table. It did not get approval. Therefore, you need to do a motion to deny it.
Can I ask a question?
And you don't have to vote for the motion to deny it, but there needs to now be a motion to deny it.
Quick question from the applicant. Is there anything else that I can stipulate that would allow this enclosure to be built? I'm trying to do everything possible within the realm of the law. As Mr. Longworth mentioned, this should have been part of the process. I did not understand at that time, in 2022, that it was, otherwise I would have included it in the initial vote, which I understand would have had the same hardship that was already determined. So I'm not sure, why at this point we've gone through, all of the process of coming back in front of the board to get this right this time. If I had that, I would have a pool enclosure right now, today.
All right, yeah, because this is, the difficulty with this is, and I know it's the same position you're in, I don't think either one of us wants to sit here and say, no, I absolutely do not. Unfortunately, the way the rules are written, the laws and ordinances and everything else, which is that's why I was asking the city attorney earlier if we had any other options other than to take this as a standalone application. That's what's creating the difficulty here. It's not a matter of what we want to do, it's a matter of what we can legally do.
I understand.
And I know you understand that, and I appreciate it, and I'm sitting here trying to figure out a way that we can do this, but I don't. So we're gonna have to. So somebody has to make a motion tonight. Is that what I'm understanding?
Yeah, one of you has to do it.
Okay.
And if that is the case, is there any other recourse regarding this issue? I'm happy to do whatever, when I left here last time, there was a stipulation put in place for the wall. I didn't originally intend for that to be included in the ordinance. I wanted to do exactly what this board asked in order to make that happen. Construction of concrete block wall and then fauling out the facade to make it match. All of that, the construction of the gate, none of that was cheap. I'm trying to make sure that I'm going through the proper process here. It was an oversight, as was mentioned, that this was not included the first time around, but my understanding, based upon conversations with city staff, was that this determination would include that. I didn't realize that it wasn't in the order until this year, when Michael Sherman emailed me that. I'm happy to, make sure that all of these stipulations that Mr. Hall put in place are, followed to the T. Again, I don't want to, come back and bother this board ever again. I don't intend to. But I do feel like this is, an issue where I'm a resident and trying to, do the right thing. And I'm, in a position where I might be denied based upon, and also too, think about the situation. If there is, we don't know where the city council is on addressing these issues. But my understanding was 2 years ago, this board asked the city council to address them. I don't know where they are at that process. If there is some sort of law that you don't feel is just or you don't feel is correct and needs to be arranged, do we just keep having people penalized who are or do we make a change? And this is why this board exists, is to make that change possible. And who knows, if this is denied, I have to recalibrate my plans on whether or not I go home and tell my family, hey, this isn't going to happen. We might have to sell the house because I'm committed now to cleaning out this pool on a daily basis for the rest of the time we own this property. And so I have to figure out if that's what we want to do. And at some point, as I get older, or as costs rise, because we don't have a pool cleaner right now, I have to figure out if that's the case. And I don't want to do that. I don't think that is the right move. We love the community. We're here.
This hearing is closed, so I don't know why we're listening to further argument on this.
Are
It's
we
now in the
allowed to-
purview of the board.
Are we allowed to talk as the board?
You're allowed to talk as a board. Also, I guess if looking to the future to answer the question, perhaps waiting till council does consider changes in the land development code. And in the meantime, there's such a thing as retractable pool covers. So, there is that option to wait for that. Also, if the applicant doesn't like the way this goes, if he feels that he meets the criteria for it, he can also file a petition for writ of cert with the circuit court and argue it there.
For the board, I know I mentioned this earlier, and you had stated that, you could build a lanai back here, just a very small one. Could you actually build a lanai with those two oaks there and the power line? Because of the roots and stuff? So I'm just wondering if that is a true, those are land, right? Those two oaks. And so I'm wondering with the roots, it says it's a 48-inch oak. I would imagine the roots on that thing are
No, it was pretty.
significant. So that's what I'm just saying, is it an actual hardship? Because could you build a lanai there at all?
I think the question is that it's
Yeah.
having a lanai, having a.
I don't think
Yeah.
there's
not a
any.
hardship.
Yeah, that's the part. It's the lanai itself is not a hardship.
I see what you're saying.
And that's where I'm struggling too.
Yeah.
If I understand all of, everything that's been said, but that's the hard part is then, and I go back and look at what we are allowed to do and what we're not allowed to do, and I try to keep that as accurate as I can.
I feel like the LA Bank commercial where they say, do you want the pony? They give the one the toy pony, and they give the other one an actual pony because like you didn't ask. And that's how I feel right now with this board because of a formality from 2 years ago.
But perhaps that is better addressed with the circuit court. I mean, that there was a error, and that is an error that they can fix. That's not an error, I don't think that's an error we can fix. That's an error, something that that's an error a court could fix if that's the way they determine it. That there was a misunderstanding error or whatever the right legal terminology is.
And this isn't considered his backyard because it's on the back half of the property?
I could say at the circuit court, I file motions for clarification. They get granted by the judge. I do this in my daily practice. We don't have that recourse option, but that would be available to me as an attorney filing stuff at the court would be like a motion for correction. I have 15 days to do it after a hearing. So I just feel like the LA Bank commercial.
I'm just thinking if you split the property in half, technically it's on the back of the property.
And the wall is now,
Does the ordinance say behind the home? Behind a home, or it says the rear of the property?
You mean like the ordinance, the ordinance, oh, sorry, I'm thinking of
Yeah.
the order. It has to be to the rear of the property, and the rear of the property
Oh,
is.
your mic's not on.
It has to be to the rear of the property, and the rear of the property, a rear yard is defined by the rearmost point of the home. Under current regulations.
so if I were to build an addition behind that wall, would that help designate what is the backyard based upon that?
It would not, because it has to be the rearmost point. So the most rear wall of your principal structure will then define where the rear yard is.
And that's the
That's
the basis of the original hardship
exactly.
that was granted.
Exactly.
And the other thing that Mr. Hall brought to my attention is that, when this board 2 years ago granted this, and asked the city council to deal with these issues, my understanding is that the issues that they're reviewing in regards to accessory structures are not going to address this particular issue. So waiting is not something that necessarily will do much.
I'm going to have to stop because the city attorney corrected me earlier, and she is correct that we've closed the hearing, so we can't really get into more testimony. So I think at this point, we need a motion to deny. I've never actually done this. Am I allowed to make the motion if nobody else does, or do I have to have a non-chairman do it?
Generally, the chair does not make.
That's what okay. Yeah, well, I thought so, but I didn't know what,
You would have to hand over the gavel to somebody else to be the chair while you.
okay, that's, okay, so I can't make it.
Or we can approve with different conditions, correct?
Correct.
Make a motion to approve with a different,
Do you have any conditions that you feel would suffice?
Do you?
I hear you, perfect.
Well, if
I
I
mean,
understand
and that's
correctly,
what-
anybody, except for me, anybody can make a motion that,
I agree with that. I was trying to think of conditions, but I mean, based off of, and that's why I asked if it's the back half of the property, is it the rear? Because if you split it down the middle, it's the rear, but if we're going based off of the definition, then it doesn't, it doesn't apply, so. It's, and a lanai is an accessory, it's not something that is required, so we can't. Yeah.
It frustrates me because we all know in our hearts it doesn't matter to us or to the city if he has the thing. This is a formality, and it's something if he would have asked for it 2 years ago, he would have gotten it. But because the bureaucracy of what we're doing, we're supposed to deny this now because he didn't ask. And truthfully, he met the criteria 2 years ago, and you
And
know.
the reason I asked that first question I asked to Mr. Hall was, he's not using up any more land. It's the exact same amount of land, the exact same structure. It's really just LNI.
If you create another,
What if we
I will have
require
a-
him to
I'll
use
have-
the really
I'm gonna-
clear screen?
no, that's okay, go
no.
ahead, I completely
No,
understand,
seriously.
but,
You can, if we require him to
But we
use the
don't- we all
really
have to
clear
agree. That's the thing
screen.
is-
right,
There's
well,
only
all
four
four
of
of
us.
us are gonna have to agree, because we don't have a fifth here, so we would need four.
Can we require him to use the really clear screen?
No.
I'm serious.
I don't
It's
think it
less
has to do
noticeable
anything
from
with
the.
They can't see it
Yeah,
anyways.
it's not about visibility, I don't believe.
Yeah.
I mean, in regards to the first approval, with what you said, the conditions, I don't think him coming back and not being able to have another variance on this should be a condition, because you never know if something's gonna happen. I mean, so,
And I'm personally okay if you want to remove that condition. I mean,
Well,
if
I
that's-
mean,
if
you
you
could
want to
say
redo the
unless there's
motion without
extenuating
that.
circumstances, like a flood, you know, like there are extenuating circumstances. I agree with Stephanie there, but.
I mean, putting a limit on the amount of variances somebody can have on their
I'm
land.
completely comfortable if we want, if you all want to, if somebody wants to make a motion to remove that, it's not going to hurt my feelings at all. I put it in there to try to bring some finality, but if it's overstepping and it's going to create unintended consequences, I do not
But
want to do
then,
that.
by doing that, aren't we also making it for anybody who buys this property in the future cannot also, or does the
Correct.
variance go, the variance stays with the land?
Yeah.
Not with the
Correct,
homeowner.
so-
So
right.
if somebody else bought this land and wanted to get a variance in this area, they couldn't.
Well, I mean, the pool was put there very specifically because the backyard was loaded with trees and power lines.
Correct.
And mostly trees, and that's why the pool was there. So there was strong reasoning why the pool was put there, and there was conditions with it. So I mean, in terms of basically asking whether or not there be no further variances, I don't care about that. It's something I was doing it to try to please the city to vote yes because I wanted this to win. So that's why I was willing to say whatever that he would agree with to make this work. But I don't care about that provision.
I mean, to me, that just seems kind of
With the,
like it goes with the land and,
with the pool, I wasn't a part of the first case. So with the pool, is that the only variance was just the location? There wasn't setback variances or anything like that?
nope.
Yeah,
So it was just the location from the back to
Yeah,
the
the
side?
backyard was loaded with trees and power lines, and he had to cut down like a whole bunch of trees.
He did make the minimum,
Yeah, he
size.
Went through a lot of trouble to
Yeah.
make sure it
As
fit
far-
with the minimal amount of damage, yes.
Put it as far back
absolutely.
as he could go, within reason, and it was a lot of compromise, and we approved the variance. We approved it for that location, for that piece of land to put the pool there. I would have guessed he could have put the screen there. I didn't even think about that, and I mean, it's. I understand we're held to these draconian standards if they didn't think of the screen back then or ask for. I wouldn't think of it either.
Site plans do have setbacks on them, at least proper ones. So
Yeah.
even if it wasn't expressed in the granting letter, the site plan is binded to setbacks. I just want to make that clear.
Yeah, no, I just wanted to see if that variance, he was doing
He's not
setbacks
encroaching-
plus
no,
that,
he wasn't
plus that, yeah.
encroaching into setback.
Was it layered, or was it just one thing?
All right. Well, at some point, we're going to have to make a motion for something here, so,
I'm happy to make another motion for approval without that one condition. I don't know if that will impact the thoughts or feelings of the remainder of the,
I would be more comfortable with that
Uh-huh.
motion. And the previous one, we're saying like, that locking into this land and for all eternity. But I don't know how Stan feels.
yeah, I'm really stuck on this one because I understand what the rules say and everything else. And I know the intent is for this board to be able to solve problems that the land creates.
Yeah.
But I'm almost feeling like, we inadvertently created this problem. That was probably just, as you said, we didn't think of it. And quite frankly, looking at the date when this happened, I think this was I think it may have been our first or second meeting as a board.
Yeah.
And it's, what's really I'm struggling with is that I don't feel like it meets the criteria that it needs to, but I still, at the same time, I do feel like that there is a hardship here that it's, while maybe not directly created by the land, it was partly created by the land and partly created by us. And that's why I've really been trying to sit here this whole time and come up with some way to fix this. I don't think there was anybody, I agree, on the board, since we were all on the board at the time, that would have said yes to the pool and no to lanai.
Yeah.
and I'm assuming you're not allowed to cut down those oaks.
Yeah, that was the live oak that's
The
what
issue.
started the entire
Yeah.
issue. That
And the oak is-
Tico contributed and a lot of other things happened.
And the oak is what's causing the problem?
Yes.
I also want to just speak to you one time. Basically, the part of the reason he didn't ask for it was because the then existing staff, that was his hearsay, I mean, we're not at that standards, apparently told him he could put the lanai there. He never thought he couldn't do that until he applied for the permit this time. Like, this was the understanding, and based off of, well, it's part of his presentation, and we're not excluding hearsay technically. If he said it, then he says that he was told that verbally that he could do this with the last variance that he was granted. To me, that's kind of, a little bit problematic, you know, that to deny it whenever, I mean, I like basically the city to be held by what they say they're going to do or what they say they can do. And it makes me wonder if that was brought up to him at the time, he would have put it in there.
Well, and I don't recall any discussion on it, but I don't recall that we didn't. And Jennifer, if I understand correctly, there was some problems with the recordings that night. They don't exist basically, so we don't have anything.
There's no recording, and the minutes didn't have much in there.
Because I think that would have been the natural thing, would have been gone back through all of the testimony that was presented and see if it was discussed. I don't recall it, but that certain, you know, but I don't recall what I had for breakfast either. So, you know, that doesn't mean a lot.
That recording cannot be located, I've looked.
Okay. So we would be down to simply what was in the minutes, which would not have any detail, because that's the other thing that could have very well been in here that would fix this if there had been mention of lanai, but we have no way to go back and fix that.
Doesn't work here anymore.
And and Gus isn't here anymore, and I know this is not how we're supposed to fix things, but you know, what I'm still trying to bridge is that this would have been granted. The same hardship exists. This is a separate. The only difference is this is a separate application. 20 months later, if this had all been together, it would have been approved without any difficulty.
Yeah. And I also wanted to point out, I mean, yes, you have to follow, you do have some discretion in how you vote too. I mean, this is we're here to make the calls on these, about this. That's what we're here for. Basically, we're interpreting the law. There's also some human interpretation to this with this process. Like, we're not up here as robots. This is something we have to consider, the fact that it would have been approved if they would have asked for it.
And one of the parameters is they have to do the minimum, right? And
Correct.
he's doing the minimum.
And I think
the
that was the minimum,
absolute
because I think
minimum.
the height restriction was 13 feet, right?
And he's under that.
Yeah. Was that correct? Was it 13 feet?
13 something, yeah.
13?
In the proposed condition, it is 13 feet. As your choice if you would like to adjust that, if you feel it is not the minimum.
No, I wrote down 32 for some reason, and then I thought, I don't even know where that, yeah, we don't need to build it. That's bigger than this building, but that's, well, would you,
Can I,
just,
this is, I was just looking up what your rules and things are, and I wanted to correct something I said. It said, all official actions of the board shall require an affirmative vote by no less than 3 members. So
Okay.
if you get 3, one way or the other.
Tony, would you like to make a motion, or basically repeat the motion without the 4th condition, or however I'm not gonna put words in your mouth, but,
That's fine, I just haven't done a motion, actually, the whole.
you need the sheet,
I
or?
have the sheet, I just want to
Okay.
make sure I have the address and all that rigmarole. Okay. I move that with the variance request for case BA, 24-03 for property located at, trying to find the right address. Thank you. 332 Ferncliff Avenue be granted as depicted on the site plan presented at the public hearing for a lanai based upon the petitioner meeting the burden of proof with regard to hardship criteria set forth in section 12-72C3 of the City of Temple Terrace Code of Ordinances for granting variances as stated in the evidence provided in this public hearing, specifically that based off of the previous approval of hardship for the pool that happened in 2022 and because of the miscommunication by city staff. I propose this with the conditions, the 3 conditions stated in the city report.
All right, does the motion have a second?
I second.
Okay, everybody say, all right. Let's raise our hands this time. I just want to make sure so we get that. All in favor, please raise your hand. All opposed? Thank you. Mr. Benjamin, go build an eye, sir. Thank you for your patience.
Screened enclosure is different than a
I'm sorry,
lanai.
no, don't build an eye, excuse me, that's for the Golden Girls.
Screened enclosure.
Yes, sir.
Mr. Hall, you mentioned the survey. Can you repeat what exactly, because I'm going to start that process like tomorrow.
I think it's after the fact.
It's on the granting, but it is a new boundary survey at the time of permitting.
Oh, so once this has been constructed?
No, at the time of permitting, like the permit process. So right now, you already have a building permit application in, so you would need a boundary survey to continue that.
Okay, so that's the next step that I need to take is get a permit, get a survey, and then add that to my application, and then this would be approved.
I would not put it quite like that. If you abide by all those conditions in the granting, and I review it further.
Okay, just to be clear, the conditions in the granting.
There's a 30-day appeal period. You can do what you wish once you get your permit, but I suggest you not do anything that's going to cost you any money until the 30-day appeal period is over. Because if a neighbor or somebody wants to appeal this granting, it goes to the circuit court.
Okay, so the existing plan that you have with the height is as stipulated, and that's been approved, the survey and the perimeter of the pool, and you have all of those plans already in place. I just want to make sure that I don't have to go back to the drawing board on anything.
I would like to address this under the building division. Right now, this is under a board of adjustment scenario, so I don't know if it's like the same hat, but I gotta switch it. So I would like not to talk about building permit things during the time of a variance.
Right. And I'd like to go ahead and if you, I appreciate the questions. I'd like to go ahead and get the meeting done because we've got a lot of other people here too. And then obviously you all are welcome to carry on this discussion at your all's leisure, but I'm going to go ahead and move the meeting forward just because of the hour. So is there any new business that any board member would like to raise? All right, old business. Is there any other old business to be brought before the board? All right, if not, the next meeting of the Board of Adjustment will be September 26, 2024 at 6 p.m. if needed. That's correct. Okay. If there's no other business to be brought for the board, the chair will entertain a motion to adjourn.
Motion to adjourn.
A second?
Second.
All in favor say aye.
Aye.
Aye. The Temple Terrace Board of Adjustment meeting for July 30th, 2024 is adjourned with the thanks for all of those who participated. All right.